Section 9213 of the Constitution gives provinces authority over property and civil rights, while the feds get authority over trade and commerce under 91-2. As one would imagine, the difference gets pretty messy pretty quick, and Canadian judges have to sort it out. Let's explore the jurisprudence. Before going forward, it's worth noting a couple other constitutional provisions that can bear on these situations. 9216 reserves for the province generally all matters of a merely local or private nature in the province. 9121 gives the feds bankruptcy and insolvency. 9110 gives them navigation and shipping. And 9112 gives them sea coast and inland fisheries. The following heads of power are also given to the feds under Section 91. 14. Currency and coinage. 15. Banking, incorporation of banks, and the issue of paper money. 16. Savings banks. 17. Weights and measures. 18. Bills of exchange and promissory notes. 19. Interest. 20. Legal tender. Section 121 stipulates free interprovincial trade. The text states that all articles of growth, produce, or manufacture of any of the provinces shall, from and after the Union, be admitted free into each of the other provinces. The fundamentals surrounding 91-2 and 92-13 are established in Citizens Insurance Company of Canada v. Parsons, 1881. Here, a shopkeeper's store burnt down, but the insurance companies refused to pay because he did not uphold his obligations under the insurance contract. However, the law of Ontario at the time stated that all insurance contracts must include a statutory conditions section, and that any variations/omissions to it must be added in conspicuous type and in ink of a different color. Parsons argued that the insurance companies have to pay him despite his failure to uphold the insurance contract, since the contract failed to meet these statutory requirements. The insurance company countered that this was a matter of trade and commerce, and that therefore, Ontario did not have the constitutional authority to pass this statute. The Supreme Court was split on the matter. Justice Ritchie, writing for the majority, found that fire insurance isn't really a form of trade or commerce. It's a local and private matter, and is therefore super-provincial. Justice Gwynne wrote the dissent. Since the feds were granted the trade and commerce power, they should get to regulate how trades are carried out. Insurance counts as a trade to him, so it is not amendable to provincial regulation. The province cannot be allowed to interfere with commercial business. The case was then appealed to the Judicial Committee of the Privy Council. The JCPC sided with Parsons, finding that the statute was valid and that the insurance companies must pay. Lord Montague Smith, invoking the doctrine of mutual modification, wrote that, notwithstanding this endeavor to give preeminence to the Dominion Parliament in cases of a conflict of powers, it is obvious that in some cases where the apparent conflict exists, the legislature could not have intended that the powers exclusively assigned to the provincial legislature should be absorbed in those given to the Dominion Parliament. So, if a broad power on one side seems to subsume a narrower power on the other side, one may conclude that the narrower power was meant to be carved out of the broader. The interpretation of provisions must be done in light of each other. Civil rights include contract rights, according to the standard meaning of these words. Plus, the fact that the Constitution felt the need to specifically allocate certain kinds of contract, promissory notes, to the feds hints that contracts generally belong to the provinces. Perhaps selling insurance is a trade in one sense, but you are not a trader who is engaged in the business of trading. Furthermore, trade and commerce must have been meant narrowly, since if it were meant widely, many other federal powers would be subsumed and therefore redundant. On these grounds, the court concluded that the federal authority to legislate for the regulation of trade and commerce does not comprehend the power to regulate by legislation the contracts of a particular business or trade, such as the business of fire insurance in a single province, and therefore that its legislative authority does not in the present case conflict or compete with the power over property and civil rights assigned to the Legislature of Ontario by Section 9213. Now, 1881 was a long time ago. Let's get into the modern test for the trade and commerce power. There are two branches of the trade and commerce power. The first branch provides that the feds can claim jurisdiction when the pith and substance of the legislation is the regulation of international or interprovincial trade. In such cases, incidental effects on intra-provincial transactions are fine. I'll go over a few cases for fun. First is Murphy v. Canadian Pacific Railway, 1958, SCR 626. Here, a BC guy buys grain in Manitoba, but the railway refuses to take it to BC because only the wheat board can traffic grain interprovincially. The buyer claims that the federal statute breached his property rights and was therefore beyond federal power. The court disagreed. It's intravirus since the law regulates many trades, and this regulation is directed at interprovincial trade. The intraprovincial effects here were found to be minor and incidental. At the very least, the feds can regulate intrastate activity insofar as it affects interprovincial commerce. Next is Colloidal v. Canada, 1971, SCR 543. Here, the federal government passed a law banning north-south pipelines in order to make Ontario and Quebec buy Albertan oil. The original law was struck down due to property rights infringement, but the new version at issue in this case was upheld unanimously as a regulation of international trade, as the new law applied only to imported oil. Import control is a federal power. Let's move on to Dominion Stores versus R. Here, an Ontario farmer sold apples within the province under the Canada Extra Fancy label without meeting the quality requirements for it, which are set out in a federal statute called the Canada Agricultural Product Standards Act, or CAPSA. A provincial law, the Farm Products and Grades in Sales Act, also rendered the farmer guilty under provincial law. The court found that the federal provisions under which the farmer was charged were outside the power of the federal parliament. The feds do not get to control local trade just by stuffing their regulations of intra-provincial commerce into a broader federal scheme. We don't want to duplicate the regulation/administration of stuff. And in this case, according to the court, the federal statute seeks to add another consequence to the same action already prescribed under the Ontario Act. So, if you're having trouble with the federal trade/commerce statute that regulates intra-provincial business by essentially duplicating a provincial law, you could try to use that as ammo in a validity challenge. The second branch of the trade and commerce power provides that the federal government can engage in the general regulation of trade affecting the whole Dominion. The federal government can regulate production and exchange within a province when the federal measure regulates a national economic issue affecting the whole country. The test is flexible and vibey. You have to balance the national interest with provincial autonomy. Some guidance is provided in General Motors of Canada Limited v. City National Leasing 1989, which gives us a non-exhaustive list of indicia to consider. The 5 criteria are as follows. The more you have, the more likely the feds can win. The impugned legislation must be part of a general regulatory scheme. The scheme must be monitored by the continuing oversight of a regulatory agency. Third, the legislation must be concerned with trade as a whole rather than with a particular industry. The legislation should be of a nature that the provinces jointly or severally would be constitutionally incapable of enacting it. And lastly, failure to include one or more provinces or localities in a legislative scheme would jeopardize the successful operation of the scheme in other parts of the country. Note that the presence or absence of any of these 5 criteria is not necessarily determinative. You have to do a careful case-by-case analysis. Together, factors 4 and 5 are sometimes referred to as the provincial inability test. So if anyone mentions something like that in the context of a 91-2 analysis, you now know what they're talking about. You also need to keep in mind the incidental effects, double aspect, and ancillary powers doctrines we discussed in my validity video, since there is a severability risk in cases like these. According to the opinion in General Motors, if the scheme of regulation is declared valid, the court must then determine whether the impugned provision is sufficiently integrated with the scheme that it can be upheld by virtue of that relationship. This requires considering the seriousness of the encroachment on provincial powers in order to decide on the proper standard for such a relationship. Let's get into some examples of the GRT branch. We'll start with the epic fails, Labatt and Canadian National. In Labatt Breweries of Canada Limited v. Attorney General of Canada, 1980, a brewery exceeded the maximum light beer alcohol content and labeled it Special Light Beer. The government sues, and Labatt defends themselves by calling the Food and Drug Act ultra vires. The government says that the act is covered by 91(2) and is therefore intra vires. Labatt won. The regulation at issue was concerned with production and local sale within a single industry. It does not cross borders. Not even the general trade power extends this far. Justice Laskin dissented, though, as Canada was meant as an economic union, see Section 121 of the Constitution. Establishing uniform labeling standards is needed to maintain fair competition, rendering the Food and Drug Act justified under the federal power over the general regulation of trade and commerce. I'd also like to briefly mention AG Can v. Can Nat Transportation Limited, 1983, 2 SCR 206. The Combines Investigation Act was at issue in this case. I won't get into the details, but the court noted that the line of demarcation is clear between measures validly directed at a general regulation of the national economy and those merely aimed at centralized control over a large number of economic entities. Also, as an aside, you can find a good normative critique of the general regulation of trade inquiry in Jean Leclerc's 2010 article in the Osgood Hall Law Journal. Please, draw me a field of jurisdiction: regulating securities, securing federalism. Finally, in case any of you run into a trademark problem, I'll mention Kirkby AG v. Ritvik Holdings 2005. A Lego brick manufacturer says that the stud pattern on Lego bricks is a trademark and anyone else who uses it is infringing, and they sue a generic manufacturer. The generic manufacturer says Section 7B of the Trademark Act was ultra vires parliament, but it was ultimately upheld under the 5 General Motors criteria. Let's go over some more recent applications of the GRT branch of the trade and commerce power. First, the securities reference. The proposed federal legislation would impose certain securities regulations on provinces based on a voluntary opt-in system. The feds defended it on 91(2) grounds. The provinces attacked it on 92(13) grounds. The pith and substance of the statute was to establish a federal scheme for the regulation of securities. The idea was to produce a follow-through effect, where all the provinces would hopefully sign on to enjoy the benefits of having a similar scheme to their neighbors and dissolve their provincial regulatory schemes. Property and civil rights were clearly overridden by some provisions of the law. These regulations frequently duplicated provincial law, but in the court's view, there is a special federal aspect that justifies the overlap in this case. That is, to establish efficient nationwide capital markets. In seeking this objective, the broader act goes beyond provincial powers. In case any of that wasn't clear, I'll quote the court directly. The purpose of the proposed act we have seen is to implement a comprehensive Canadian regime for the regulation of securities with a view to investor protection, the promotion of fair, efficient, and competitive capital markets, and ensuring the integrity and stability of the financial system. The effects of the proposed act would be to duplicate and displace the existing provincial and territorial securities regimes, replacing them with the new federal regulatory scheme. Thus, the main thrust of the act is to regulate on an exclusive basis all aspects of securities trading in Canada, including the trades and occupations related to securities in each of the provinces. So, this counts as trades as a whole. Securities are involved in numerous industries. The first 3 factors of the General Motors inquiry are easily met. But Factor 4 is not met. Provinces can and have regulated many aspects of securities. Provincial inability is absent. The provinces would be unable to make something like the Act happen, but the Act goes way beyond the things that only the federal government could do. It would eclipse the whole arena of provincial securities regulation. This finding was not good for the federal case. The feds argued that a missing province would wreck the whole scheme under Factor 5 from GM, but the court didn't buy it. They held that because the main thrust of the proposed act is concerned with the day-to-day regulation of securities, the proposed act would not founder if a particular province declined to participate in the federal scheme. Incidentally, we note that the opt-in feature of the scheme, on its face, contemplates the possibility that not all provinces will participate. So, the Act failed factors 4 and 5. Overall, the feds had to lose because provinces were able to accomplish the main thrust of the federal legislation themselves. Though the provinces won that battle, the feds would win the war with the 2018 reference Pan-Canadian Securities Regulation. This time, 6 provinces and territories agreed with the feds to join a cooperative national securities program. It contains a model provincial statute and model federal statute, alongside a national securities regulator, directed by federal and provincial agents. Neither statute had force of law yet at the time of the case. The Quebec Court of Appeal said it would be unconstitutional because it included a requirement that would fetter the sovereignty of provincial legislatures by requiring amendments to the provincial legislation to be approved by the Council of Ministers, and would also violate the federal government's sovereignty by allowing Ontario or BC to veto proposed federal regulations made under the proposed statute. The Supreme Court overturned this decision on appeal, finding the proposed legislation constitutional. In their view, provincial legislative sovereignty was not constrained because the proposals from the board have to be ratified by the provincial legislatures to take effect. Plus, when an action of the executive branch appears to clash with the legislature's lawmaking powers, parliamentary sovereignty can be invoked for the purpose of determining the legal effect of the impugned executive action, but not its underlying validity. Any executive agreement that purports to fetter the legislature is not inherently unconstitutional, but will simply not have the desired effect. The pith and substance of this act was found intra-virus parliament, fitting into the trade and commerce power, as it was pretty clearly focused on stabilizing the national economy. Unlike in the previous securities reference, day-to-day securities regulation was not included. It was found to complement, rather than duplicate, the provincial legislation. The last 2 General Motors indicia are met, whereas they failed last time. At paragraph 103, they run through the 5 GM factors and find that the legislation relates to trade as a whole under the second branch of the trade and commerce power. So, the feds win in 2018, albeit with their powers considerably more encumbered than they would have been under their proposed 2010 legislation. Guess that's it then. See you next time.